In the case of Bruton and London and Quadrant Housing Trust, a block of flats were owned by the City Council. The council then granted a license to the London and Quadrant Housing Trust to use the block of flats. The trust in turn used those flats as accommodation for the homeless. One of the people that they gave accommodation to using the flats was Mr. Bruton. The flat eventually fell into disrepair, and Bruton tried to argue that the trust was under a statutory obligation to make the repairs. For this argument to succeed, it was imperative that the agreement between the trust and Bruton was a lease and not a license, thereby making the trust a landlord. The trust counter-argued by pleading the nemo dat principle, which is essentially the principle that states that no one can give what they do not have. Because the trust only had a license from the council, it did not have the requisite title to create a lease. They argued that it only had a power to create a license. Therefore, according to them, there was no lease, and the relationship between the trust and Bruton was at most one of licensee and licensor. Therefore, they argued that the trust was not liable to make those repairs as a landlord. The House of Lords held that Bruton had a lease. Lord Hoffman stated that a lease may and usually does create a proprietary interest called a leasehold estate. This would depend upon whether the landlord had an interest out of which he could grant it. But it is the fact that the agreement is a lease which creates the proprietary interest. It is putting the cart before the horse to say that whether the agreement is a lease depends upon whether it creates a proprietary interest. In other words, Lord Hoffman here is saying that what is important is the agreement itself. It is the agreement that creates the proprietary interest and not something else, like whether the landlord had the requisite title, etc., etc. He goes on to say that in this case, it seems to me that the agreement construed against the relevant background plainly gave Bruton a right to exclusive possession. There is nothing to suggest that he was to share possession with the trust or anyone else. The trust did not retain such control over the premises. The trust's lack of title is also irrelevant. Now, this decision has been criticized by many academics. The traditional view is that only a holder of a legal estate, i.e., a freehold or a leasehold, can grant a lease which creates a new proprietary interest. However, what the case of Bruton effectively does, it states that even a non-holder of a legal estate, i.e., someone who does not have the freehold or a leasehold in the land, like for instance a licensee in this case, can create a lease, provided that the requirements of a right to exclusive possession for a period of time in exchange for rent payments is met. This kind of lease has been described as a non-proprietary lease, or a contractual lease, or a Bruton lease, but its nature is effectively the same as any other lease.